begin. We're here in our case 1CA-SA 20-0108, Mcgarvy versus Dr. Shaffery, real party in interest. Each side will have 20 minutes to present their argument. Counsel, you'll have to keep track of your own time. Petitioner, you have the right to reserve as much time as you want for rebuttal, but you'll have to keep track of that time. We're recording the argument, so when you speak, please identify yourself and your client so that if we go back to watch the recording, we can keep everybody straight. The video will be on YouTube in a few days. We've read the pleadings and we've conferenced the case. We understand the facts and the issues. So when you begin your argument, just begin with what you want us to know. A question that I think we all have had, and if you can begin with this, we're unclear about exactly what relief you're asking the court to grant. So if you could begin with that, we'd appreciate it. You may begin.
Thank you. Good morning, I'm Jessica Gattuso, and I represent crime victims Renee and Christy Mcgarvy on behalf of themselves as well as the minor child IM. I'd like to reserve 5 minutes of my time, if I may, for rebuttal, and I want to thank you all for giving me the opportunity to be heard today. In this case, the defense is incorrectly using 6.7 rule, a procedural rule, to exclude victims from litigation over their confidential records. And I will start with the question Your Honor posed.
Oh, yes, please, go ahead.
Well, first of all, I want to point out they're incorrectly using 6.7, and it's illustrated by the fact that you have Appendix D attached to Real Party's response to my special action. You have a document I've never seen. I don't know what's in it. I don't know if you've considered it. And I don't know if your decision will be based at all on Appendix D. I could sit here and make counter arguments. I could try to make every conceivable argument against Appendix D, but that would be a waste of time, and that's why this is fundamentally unfair. It's unfair to exclude the victims from notice and the opportunity to be heard on everything judges are relying on in making their decision. And the relief, I'm sorry.
Well, counsel, but as I understand the record, with a possible exception of Appendix D, you were able to file pleadings, you were able to argue to the court on these matters, and as I understand it, the personal identifying information that is you're entitled to have redacted has been redacted. So I'll come back to my original question. And I understand the argument that the court is misusing the rule, but I guess what I want to know is what relief can we give you?
Okay, so the procedural history in this case is somewhat complicated, but I think...
Can I interject? And just which particular ruling from Judge Duncan are you challenging?
So there's two. There's the issue of inadvertently disclosed DCS records that the defense has never provided openly a basis for having or retaining those records. They've never, well, they started with asking...
But didn't the Superior Court say you can't do anything with those? Are you saying that the remedy that the court imposed was not adequate? Is that your argument on that one?
Yes, I think this needs to go back. The defense needs to provide a legal and factual basis under the Connor, Cerullo, Kellywood, Thompson cases for retaining that information. They've never openly provided the basis for retaining the inadvertently disclosed documents, to include highly personal information my client's home study that includes her financial status, her medical history, her children's medical history, where her children go to school. The defense has never provided a basis for having that information or retaining that information.
Sorry to interrupt. Could I ask another question? How much of these documents were prepared as part of severance proceedings? What, was the defendant a party to some of the proceedings? Was he entitled to the documents as part of those proceedings?
Yes, Your Honor. He was part of the dependency proceedings, which is originally what the judge ordered. Respondent judge ordered him to receive what he would have received in the dependency case. But these documents in that case, it's my understanding, would have been redacted and limited to only the information involving the real party in interest and possibly the child IM. But
are there any documents that are post-severance hearing? What you're talking about then are all documents that were part of severance proceedings?
We're talking about documents that go back to 2002 all the way through, I believe, 2019, which was past severance, past adoption. They inadvertently received unredacted, except for the four big, they call it the big four, the social security numbers, criminal history, reporting source, and the identities of the attorneys in the dependency case. Other than those four things, they received everything. And I believe it was way beyond the scope of what they would have gotten in the dependency case. The respondent judge ordered the records redacted, statutorily redacted, and the AG representing DCS assured me that it would not include the personal information of the victims. It would be limited to the defendant and what he would have received in the dependency case.
Counsel, so is there a statutory basis to protect the other information you're talking about other than the personally identifying information that we all agree is statutorily protected?
Correct. That was rectified at the last hearing by respondent judge. However, it was left out there, other information, the home study in particular.
But my question is, what statutory basis is there to redact that information?
8-807 requires a balancing by the judge, as well as victims' rights. The judge needs to consider the victim's rights and right to privacy. There was no balancing under 8-807 because the defense never publicly provided a legal or factual basis for retaining that information.
But are you talking about if and this may just demonstrate my lack of knowledge of if a third party just wants to go and get some DCS records, if they ask for them, I assume DCS has to, they're public records that are subject to disclosure, subject to making whatever redactions are necessary. Are you suggesting that if anyone else had asked for these documents, they would have been provided? Would they not have been provided with just the statutory redactions? Are you saying something more than the statutory redactions should have been redacted?
Yes, I think under 8-807 requires the judge to weigh and balance the person requesting the records versus the right to confidentiality, and because these are victims, consider victims' rights when making that analysis, and if possible, do whatever they can to uphold these victims' rights. That's what 8-807 requires.
But in some sense, the redactions were inadvertent. I mean, leaving them unredacted was not because of the judge's order. It was because DCS inadvertently disclosed that information, correct?
Part of it, correct.
Well, what other part isn't? Because looking back at her order, she ordered them disclosed with the statutory redactions, correct?
Correct. So there's two motions that we're talking about here. One was my motion asking for that inadvertently disclosed information to be returned or disgorged. And another one was that the defense's motion requesting further unredactions, those four items, the criminal history, reporting source, that information. So they requested further unredactions.
And the judge didn't grant that, though.
She did grant that. and partially based on the ex parte filing.
So you said there's 4 areas. It's criminal history. What else?
Criminal history, social security number, which I think is, we're covered with that because she said that should be part of the locating and identifying information. So it's criminal history, social security number, reporting sources, and the identities of attorneys in the dependency case, guardian ad litem, things like that. So there's my motion asking for that back, the inadvertently disclosed information to include the home study, but there's also the defense motion asking for full unredactions and my objection to that.
Okay, but she didn't order full redactions, unredactions, did she?
She did, partially based on the ex parte pleading.
So you're saying they're entitled under Judge Duncan's ruling to keep the entire unredacted file that they got from DCS?
With the exception of the locating and identifying information, correct.
Okay, so you're saying the report, the home report, and you're saying that's not a statutory redaction, but that's a redaction that you would have requested who's ever mentioned in that in the DCS records would request be redacted?
Absolutely, we would have, yes, we would have asked, and I would believe that would be statutory required in even the dependency case, and we would have.
I thought you said it's not a statutory redaction. You're wanting something beyond what's. Let's assume DCS had turned over the records in the correct format with all of the statutory redactions. At that point, you're saying the defense is asking for what? Or you're going in and asking and saying we need to redact more than what's statutorily required? Is that the position you're taking?
I'm taking the position that, well, I accepted Judge Duncan's order that he was entitled to what he would have gotten in the dependency case. But after that, the defense requested more unredactions, and we objected. We asked, and the judge ordered more of a factual and legal basis for more unredactions. And that's the point where we began the litigation over the Kelly Wood Thompson basis for the defense requesting more unredactions. And somewhere along the line, they ended up with.
I thought you said they're not. I guess what I'm not clear on is if this information wasn't subject to statutory redactions and it's something that you want to have redacted, it would be your motion to redact something. They're not your these are DCS documents, and so you want to come in and redact something. That seems different than saying the court improperly unredacted something. So I'm having a hard time understanding which. If we could start from the premise that the only thing that should have been turned over was the statutorily redacted documents, they request those. They should have only been. Everybody's in agreement that you shouldn't turn over things that are required to be redacted under the statute. But at that point, you were wanting them to redact more than what was statutorily required. That's different than unredacting. Because we're saying they should have gotten the redacted copies. Could you clarify that for me?
I just want to clarify what happened factually and procedural in this case. So in the beginning, defense they filed a motion for disclosure of DCS records. There was absolutely no factual or legal basis for requesting it at that point. And it was granted before the victims or the state even responded. So then we got involved, we objected, we said we need more than just a request for DCS records. We need a factual and legal basis under 8-807. So then months later, they filed another motion, again, not identifying what exactly they were requesting and why. And at that hearing, at that oral argument, they handed over an outline of each page of what they wanted unredacted. That's the first time they provided specific information of what they wanted unredacted, or what they wanted from DCS, I'm sorry.
Are you talking about the January 13th, 2020 oral argument where the court ordered that defense file a motion specifically identifying what information they're requesting to be unredacted?
Yeah, so I'm sorry, I should back up. So their first motion, there were no details, but then the court ended up ordering the defendant to get what he would have gotten in the dependency case. Okay, that was the first round of litigation. She ordered statutorily redacted records to the defendant from the time of the crime to severance, but subject to statutory redaction. So that was ordered
September 17th.
Yes.
Okay.
And then
Do you
after
disagree with that ruling? Do you take any issue with that ruling? That's not what you're challenging here, right?
No. So then they got those records and they asked for more unredactions, but they didn't provide a legal or factual basis until we got to oral argument. They handed us a document that said what pages they wanted unredacted, but didn't specify why or what their due process need was for that information. So then in February of 2020, that's when they filed the motion detailing why they needed that specific information unredacted, and their legal basis for requesting it. At that point,
and you saw those pleadings.
I did, yes. And at that point, the defense provided myself, the state, and the court with what they had received from DCS, and we realized they had received more than what was statutorily required to be redacted. They received more than what they would have received in the dependency case. So we realized in February that they had information the judge hadn't ordered, and they've never provided a legal or factual basis for having it or retaining it. So at that point, I filed a motion to rectify that inadvertent disclosure, and their only response was, we've already litigated this. They never provided a legal or factual basis for getting that information or retaining it. They also...
Well, so your argument to us is that the court erred in its ruling on that motion.
Yes, because she did not require a showing under the Kellywood-Thompson cases openly where I could litigate it. It was all done ex parte on that.
Well, I'm confused because you're litigating that in front of the judge. I don't understand how that's ex parte.
I asked for it to be disgorged in return because defense shouldn't have had it, and they never provided a basis for having it. And their response was ex parte. I don't know what the basis was for her allowing them to keep it.
You've only got 4 minutes left, and I don't know that I've been satisfied about Judge Howe's first question was, we've gone through all this, and I'm not sure if you win, what is the relief that you're seeking? What is our order supposed to look like? Because I feel like we've gone a little bit around, and I don't know the answer to that question, and I think you would want me to.
Yes, so very quickly, I want two things. I want this to go back to the trial court for litigation openly about why defendant is entitled to this information. The victims are entitled to know every basis under 8-807, Rule 15, and the Roper line of cases, why the defendant, why his rights trump the victim's rights, why he gets to keep those records, and why he's entitled to more unredactions. Because the judge admitted she relied on ex parte information in making that ruling, and that's in violation of victims' rights. So I want to go back and litigate that.
But part of it is that you do not agree with her remedy, which was to put a protective order on whatever information that defense had already received.
The
because
protective order,
told in some sense about what should happen to those records, and that is they were disclosed inadvertently. They shouldn't be able to use them, but they have them. It's already out there. So I'm issuing a protective order so that no one can use them and they can't be disclosed to anybody. So you also object to her remedy in issue number 1.
yes, I think the protective order has to do with the locating and identifying information, not the inadvertently disclosed all of it. And I can't even challenge her ruling because I don't know what it was based on. I can't even make a legal argument.
But you can tell us what you want to have redacted, right? You've seen the documents, and have you indicated what it is that we should that she erred by not redacting?
The biggest thing for my clients is the home study. There's been no basis for retaining that personal information about my client and her kids. and how the defendant has a due process right to that information that trumps their rights, victims' rights. And very quickly, I also want to touch on that this is an important issue that is constantly happening in capital cases and evading review. So not only do I want release specifically to this case, but Rule 6.7 needs to be clarified by an appellate court. When a defendant is seeking victims' records, Rule 6.7 is not the appropriate rule to be used to obtain victims' records. That is way beyond the scope of Rule 6.7. And this court needs to clarify what the scope of Rule 6.7 is, because I can tell you as an officer of the court, judges are all over the board on what they're allowing under Rule 6.7. And bottom line is it should not be used for victims' records or any records where someone has standing to weigh in on whether or not the defendant is entitled to those records. So I'm seeking two things: relief in this case specifically to go back and litigate openly the defense having these records, but also clarification on the scope of Rule 6.7. Thank you. I'll save my 45 seconds.
Thank you, counsel. Counsel?
Muted.
Counsel, you're muted.
You're muted.
You're muted.
Good morning. My name is Raquel Centeno-Ficure, and I represent Mr. Shaffrey. Your Honors, just so we understand what's going on procedurally, the court initially did grant the records when we had first requested them. We then had to file additional motions because the victims objected and the state had objected to it. We then posed to the court at that point to apply 8-807K, which is what Judge Duncan did, and there's nothing to show that she didn't weigh the balancing factors in 8-807K and that she did not take victims' rights into account. Because she had a prior rotation on family court, she was very aware of dependency hearings and was very aware of what would be disclosed to a defendant. So she had ordered that the records from December of 2015 to August of 2016 be disclosed to the defense. She had seen the records in camera and she had seen the redacted version, and it was her position from the court that we were entitled to that DCS records with the statutory redactions. We then, upon viewing them, wanted the court to unredact what was redacted. So we then again filed motions asking for it to be unredacted. The court at that point wanted us to be very specific on this 500-page document on redaction upon redaction of why each thing should be redacted and where it would actually involve specific victim rights. We did do that, and we filed motions again in February of this year, listing out specifically and we grouped it because some of them fell within different groupings, why we believe that certain things should be unredacted. The court again had possession of the blank, the unredacted, completely unredacted copy, and had a copy of the redacted copy. She did her review based on the legal arguments that were provided to her from both myself and the victim's attorney, and she had decided.
The victim's attorney did not have a copy of your pleading?
No, the victim's attorney had a copy of every single pleading that included legal arguments, with the exception of one thing. There was one record where we had applied to the court first, so they were aware of this, asking to provide just mitigation facts. So this would include what our defense theory was and what our mitigation facts were, so that the court is able to decide, were the DCS records relevant to what our actual case was? Because if the court is not aware of what our strategy was or what our mitigation was at that time, the court's not going to know whether or not those DCS records were relevant and should be disclosed to us. So we took up the blueprint, so to speak, of Van Winkle, where the court there had suggested that an ex parte proceeding would be the manner and the best manner for defense attorneys to provide information to the court that would include trial strategy and work product. So it's not to the detriment of the defendant, but it gives the information that the court needs. There was no legal argument. There was no standards that the court should follow. There was nothing along those lines in the ex parte filing. It was purely, this is what our investigation, this is what our strategy is, this is what we're thinking of doing, and this is why the DCS records would be helpful to the defense regarding what our mitigation investigation was at that point in time and relevance.
Why isn't that a legal argument, though? If the court has to make a decision, does the defendant's need for this outweigh, whether it's a victim or whether it's just anyone's confidential information? I even assume this isn't the victim's information, but it's someone else who has statutorily protected information. I mean, doesn't the person who has protected information, how do they respond without knowing? If you're saying I'm going to weigh the defendant's need for this against the other person's need for this information to be confidential, if you're giving them a chance to respond, don't they need to know what's in your pleading?
No. And the reason why I say that is there actually was, it's our position, it's not legal argument, it's purely factual. It is purely, this is our defense theory. I'm not going to give the defense theory in this case, but say in another case, if the defense theory was the person's an underdog, and we need to know what the relationship was between parties, and the reason why we need to know the relationship between parties, or actually, let me back up. Our position is it can be purely just factual. We have an expert who's looking into trauma and problem solving skills. So we need to understand family dynamics. So if family dynamics includes the dynamics of both parties, that is our position where that's not legal argument. That's our defense theory, because say it was not disclosed to the state yet, and we're not obligated to disclose it to the state yet. Just as, and I'll give you an example, Your Honor, the DCS records, that is provided to the court in camera. I don't see a difference between allowing a trial court to view DCS records and making a determination of relevance any differently than a trial court looking at a filing, deciding if it is necessary due to confidentiality, and then determining, is it a filing of facts or is it legal argument? I have been before plenty of judges where I have filed an application for an ex parte filing, and the courts have said, no, I need more. This isn't, I can't look at this, or I need more than this, and have handed it back, and then we provided the different information to the court. So I don't think that trial courts, and there's no reason to believe that Judge Duncan did not do her job in this scenario. I believe that she looked at the ex parte application, which stated that we wanted to provide her with our mitigation investigation at that point in time so that she could understand why those DCS records were relevant. And she's able, just like any trial court is able, to do an in-camera inspection of records and to do an in-camera inspection of our defense theory and decide, yes, that's relevant, and no, or no, it's not relevant. There's no basis that the victims would have to dispute any of the facts that would be in our ex parte filing.
Well, let me take it out of the context of the victim making the objection. Just a third party, if your theory is the defendants had this history of being bullied, and the same thing happened with just an unrelated person, and there's some records that are required to be kept confidential, and someone else is involved. It's not a victim, but there's some statutory redactions that are required before you get documents from a state agency. Would that person's records be available to you without giving that person a chance to respond and say, no, I don't want my confidential information disclosed, and the only way I can make a compelling argument, they don't need that, they're making something up, this never happened, you don't get my records. And I'm so even out of the context of victims' rights, confidential information from involving a third party seems problematic to me when they don't have an opportunity to know why the records are being sought and to explain why their confidential information should remain confidential.
Well, that third party is not going to be able to dispute the factual basis of, if our basis in your scenario is that the defendant saying that he had been bullied in the past, he either was bullied or he wasn't bullied. That's a factual scenario. There is no basis for that third party to then object to what is in the ex parte application. Because one of the things we have to understand here is this is a capital case, and because it's a capital case, the information that we want is for mitigation purposes. And anything can be mitigation. And it only comes down to relevance and if it is relevant to mitigation. So there isn't this huge burden upon admission. And so our position is that there has to be a mechanism in place for a defendant to be able to obtain certain information that can be life-saving for him, and allowing someone to be privy to a defendant's ex parte filing of facts that have purely to do with just the defense theory of the case would encroach upon his ability to have a fair trial, and it would encroach upon his ability to have effective assistance of counsel, because an independent mitigation investigation is essential.
Counsel, your argument on that point, I'm just clarifying the argument on that point, is that the victim wouldn't have any input on what your defense theory is. It is what it is.
Exactly.
And you're informing the court of that, what the victim may think or not, what the victim may think as an observer about that defense really isn't relevant to the question of balancing whether that information should be confidential or not.
Yes, Your Honor.
Is that correct?
Yes, it is correct, Your Honor. That
So
is exactly.
Party, you're saying you can ask for any third-party records, and just by saying this is part of my mitigation theory, any confidentiality rights protected by statute are overcome by your need for this information as a potential for mitigation?
Well, we're not just saying any records, because obviously the trial court, what the trial court then does is the court is able to do a weighing of privacy rights as well. So this isn't just, I want it, and the court just signs off and rubber stamps everything that we request. We still have to give a basis through our mitigation explaining why we want those records. So everything, all the that Ms. Gattuso had been endorsed on lay out the legal arguments. Initially, it was stating that it had to be 8-807K and using those balancing rights. Then when we wanted it unredacted, we then put forth saying, okay, then now we're saying because of due process, because this is a death penalty case, he was entitled to those redacted statements being unredacted. And the court then has to make another finding. The court then did another oral argument where the victim was able to make whatever statements she wanted to make. The victim had the opportunity. She had everything laid out for her. So the trial court is the determiner. The trial court is the person that makes that final decision as far as, okay, are these DCS records even relevant? Are the materials within that are redacted, are they relevant?
Okay, but relevance is different than weighing someone's right to confidentiality against the need for them. And if someone has a right to have their records remain confidential, I'm a little unclear why that should be litigated without their participation. Why can't you make a generalized argument to the court that just says there are many potential avenues of mitigation? We think this could relate to his mental health. Why does it need to be in such great detail? If you're entitled to pursue, as you say, any kind of avenue of mitigation, why can't it be general enough that you're not giving something away by filing a pleading that whoever the third party is, whether it's a victim or another third party, could at least respond to and say, well, I have privacy rights, and what they're saying is simply not true, and they shouldn't get this.
Well, first off, I believe a third party would have the right to object to the court for those records to be disclosed.
But you're saying they don't get to see your pleading. They just get to say, don't disclose my pleadings. Don't
Again,
disclose my confidential information.
well, it's confidential information, and I guess that's where we're getting hung up on words, is because it's our position that there's no legal argument in that filing of facts. The main reason why
I'm talking about the third person, or in this case, the victim, who has a statutorily confidential information.
No, I understand that. And so, as Your Honor knows, this has been going on since April of 2019. When I filed the motion in November of 2019 asking for those records to be unredacted, the court said, this isn't enough. And the court said, I need you to go through each and every legal reason and factual reason as to why you should get these records unredacted, completely unredacted. And so in complying with the court and in making sure that the court then had all of the information, that is why the ex parte application was filed, stating that I wanted to provide them then with the additional mitigation information that was attorney-client privilege and work product. So I merely filed it only because the court asked for specificity. The court said, I need to know why each and every one of these redactions should be unredacted. I need you to tell me, legal argument-wise, what standards to use, which applies to victims, which doesn't apply to victims. So the additional filing of the facts was specifically due to the court's questioning as to why I needed that information.
Now you're saying that was a legal argument. And why is the person whose information not entitled to respond to a legal argument? Is what you've couched it now as a legal argument, what you submitted.
Well, what I submitted, what I was talking about just then, were the actual pleadings that were filed with the court, and Ms. Gattuso was endorsed on. So when we asked for this, the filing.
But when the court says that's not enough, you're filing more pleadings, and they're not in.
Right. So let's be clear. She asked, just so I can follow along chronologically. At your oral argument on January 13th, she said, you need to file a motion specifically identifying what information you're requesting to be unredacted and the basis. And then you filed in open court a motion for disclosure of specified unredacted DCS files on February 7th, which Ms. Gattuso responded to February 21st. You fully litigated that issue of what your legal arguments were in something that was in open court, correct? Okay.
All of that was in open court.
All right. And then prior.
I'm sorry.
No. And then prior to your oral argument on May 22nd, which is the order that Ms. Gattuso is looking to have relief on, you filed a motion to file the ex parte mitigation information so that there was some factual context, along with the legal arguments that you made separately and in open court that Ms. Gattuso responded to. Is that correct?
Yes, Your Honor.
Okay.
So the only thing that has been ex parte is your recitation of what your defense theory is.
Yes, Your Honor. But that's the only thing go ahead.
No, isn't that part of your argument, though, as to why you need the documents? Isn't that your legal argument as to why this information should be unredacted?
I don't believe it is. At this point in time, because there's different standards, and there's a question of whether or not we follow Roper's reasonable possibility or we follow Thompson's substantial probability. I believe that the court needed the background legal information and understanding why the DCS records were relevant. I don't think that affects the victim's ability to say that they think that the Thompson standard should apply over the Roper standard, or that Fox-Embry shouldn't be followed at all. They can still make all of those legal arguments if they so chose to make any of those legal arguments.
Because they can't make the argument that our interest outweighs the need for your defense theory, because they don't know what the defense theory is.
No, they cannot make that specific factual argument, but what they can say, though, is that they can still object to those records being disclosed. and normally they wouldn't even have the information in the records to begin with, if we're going to start from that premise. Normally it is the trial court that has the records, knows what's in the records, and makes that determination as to whether or not those records should be disclosed at all. And so they would normally not even know whether or not, they could not even comment as to whether or not those records are relevant to our mitigation investigation.
Why would they not know what their own records are if they're records of a proceeding in which they were involved? Why would they not know what those records are?
Because with DCS, well, they may know what they personally spoke to the person that did the investigation interviews are concerned. But with DCS records, those are considered confidential records. So they don't get copies of everything, just like Mr. Shaffrey may not have gotten copies of everything, especially the statutory redactions. So they never would have known who reported on them. Our argument was to the court at that point, there had been incidents where they had been reported on and they didn't know who reported on them. It was our position that we needed to know the source of the reporting, because we then could use that information through our mitigation investigation. So they wouldn't necessarily know everything that's in a DCS record, because even they, if they wanted to get a copy of the DCS records, would have to do exactly what we just did. They would have to go through 8-807K and ask the court for an order to give them those records. So this isn't a record that they would normally have a copy of everything that's in there, especially the statutory redactions.
Is there would there be a problem in putting some sort of confidentiality order on the victims? If there's a confidentiality order that's allowing you to keep some documents, why wouldn't that work to say, okay, the victims can see this, they can respond, but they can't use the information for anything else? You don't view that as an adequate remedy?
No, that would not be an adequate remedy, because, again, it includes our defense theory and it includes some mitigation facts that we have not yet disclosed to the state or to anyone. And we may very well decide not to present the theory or the facts at the end of the day, because we're still obviously in the midst of mitigation investigation. So we feel that that would encroach on effective representation, because at that point it would have a chilling effect on defense counsel as to whether or not we would even go out and seek certain records, for fear that we would be forced to disclose work product or trial strategy when that was not, when we know that that could be to our client's detriment, because it could be harmful information at this point, but we don't know it's harmful until we have all of the facts and realize, oh, okay, that's not a road we want to go down. So we cannot. Go ahead.
And Counsel, is it your position that whatever the court should have done, it has the protective order, so at this time the victims aren't prejudiced?
Well, yes, we believe that they're not prejudiced. The court ordered that we specifically redact any of the personal identifying information in the copy that we have, and we have redacted it. And we have not shared it with Mr. Shaffrey, and we have not shared it with any experts. We understand the court's order, and we are not sharing any of the personal identifying information. Those copies have, where there's an address or a phone number or anything like that that belongs to the next of kin, that has been redacted from any of our records that we were disclosed in October of 2019 from DCS per the court order.
Could I ask you on the if information is on who made a report, that in this case the victims may not know about that, is the person who made the report, their name is being unredacted, they don't get a chance to weigh in? If you're asking for someone's name to be redacted, the person whose name that's being redacted doesn't have any opportunity?
No, they don't. And the reason being is our client is facing the death penalty, and so under due process, we needed that information. We understand that it is sensitive information, and as counsel, we have not shared that information at all with Mr. Shaffrey or anyone, and the only person that we at this point would want to share it with is our experts or just within our own investigation. We also understand that it's sensitive information. So if we anticipate wanting to use that information, because these records have not been disclosed to the state yet, we anticipate asking the court how they want us to handle that information, because I know I personally don't want to be responsible with that person having any harm coming to them in the future. And so it is our position that we've made this argument to Judge Duncan. Judge Duncan reviewed the records. Judge Duncan reviewed the sources that would have been revealed. Judge Duncan compared that to what was redacted versus what's unredacted. And she had found, due to due process and our client's right to have a fair trial and effective assistance of counsel, that we needed this information in order to best represent our client.
Thank you, Counsel. We appreciate your argument. Ms. Cortizo, if you can reply briefly.
You're on mute.
Thank you. In this case, that protective order we're talking about only applies to the identifying and locating information. It does not apply, to my memory, to the inadvertently disclosed information, confidential information, and doesn't apply to the unredactions that the defense has asked for in addition to the personal identifying information. So that's not enough. In this case, the defense is inappropriately using 6.7 to circumvent victims' rights and to get around 8-807, and that should not be allowed. 6.7 does not apply to victims' records. Instead, the inquiry should be whether at this point, according to Morehart, in particular cases, why disclosure at this point would deny the defendant of effective assistance of counsel or a fair trial. And that inquiry was never done here. The respondent judge did not require the defendant to show a need for confidentiality other than conclusory rights that a capital defendant has.
Did we lose Judge Katani?
Yes.
Oh, there's Judge.
Sorry,
I
I'm
was just
here.
looking. Okay.
Sorry.
Thank you. Thank you, Counsel. Counsel, we appreciate your argument. We'll take this matter under advisement and issue a decision in due course, and we stand adjourned. Thank you.
Thank you. Have a good day.